Welcome, everybody. My name is Jennifer Lujan. I'm a project manager with Native Women Lead, and it's such an honor to be here with you all today. Please join me in welcoming today's presenter, Carrie Frias of Frias Indian Law and Policy. Carrie Frias has been practicing as an attorney for over 10 years, and she is currently the managing partner at Frias Indian Law and Policy, LLC. Carrie's practice focuses on trademarks, copyright, and the protection of Indigenous intellectual property. She also practices Indian law, both tribal and federal, and general civil litigation and cross-jurisdictional issues. Carrie's education includes a Bachelor of Arts in Biology from New College of Florida, a Master's in American Indian Studies from UCLA, and a Juris Doctor with a certificate in Indian law from the University of New Mexico School of Law. Carrie has worked in-house for multiple tribal governments as a registered lobbyist for tribes in Washington, D.C., as Chief General Counsel for the Pueblo of Powake, and was second chair in the Pueblo's bad faith gaming litigation against the state of New Mexico in federal court. Carrie has a passion for advocating on behalf of Indigenous women and children.
Thank you so much for that introduction. And I love the community guidelines because, us lawyers, we always make mistakes. So it's good to have that out in the forefront. But I'm really here today to talk about trademarks. And I think the way I want to frame it is that my is to give you the knowledge that you need so you can talk about trademarks and decide whether it's something that you need or want for your business. And I really like discussion, so please chat, and I will do my best to multitask. And I know Jennifer is going to help with that. And please ask questions. And if they don't get answered, please feel free to reach out to me directly afterwards. I really want to give you the tools so that you can have discussions about this and know the terminology so it doesn't feel so strange and foreign, but that's something you know about that you can utilize in your business. So my goal is to give you the information that you can then use. And so if you're not getting that, please let me know and I will, answer any questions or stop and we can have a little discussion. But with that said, I appreciate all of you being here and I will go ahead and see if I can get this PowerPoint up. The name of my presentation is Protecting Your Brand. So basically I'm looking at the brand as and being the most important part of your business. So whatever you are selling or providing a service for, that is the most important thing that you build up. And at one point, that's how you build yourself in the industry. That's your reputation, that's your logo and your designs, and it's the essence of your business. And oftentimes when big companies go to sell their businesses, what they're actually selling is the brand and what that's worth. So I want to talk about as Native women business owners, how you can protect that. And I like to put it out there right from the beginning, I am not Native. I am married to my husband who is Apache, and he started this law firm a couple of years ago, and I ended up taking it over. And but I always like to put that out there because I don't want you to think that I am claiming that I'm Native. I am not. I have a strong passion for working in Indian law and particularly working with Native women and children. So this is just a quote from Walter Echohawk that I want you all to just go ahead and read it real quick. And it's in an article by Rebecca Sosi on intellectual property, just governance or just war, Native artists, cultural production, and the challenge of super diversity from 2017. And she's quoting Walter R. Echohawk. And if anyone has any comments, please let me know. But I think this kind of sets a stage for the way that I like to look at intellectual property and protecting it. So there's a lot of things, in my opinion, and I'm sure you all, I don't have to tell you this, things have been stolen from Indian people by colonizers, land, natural resources, personal property, and kind of the last chunk left is the cultural rights. And so the way that I look at trademarks is a way of using sort of the colonizer system to protect Indigenous cultural rights in the US. Now, I'm not going to lie, trademark and Western legal systems and the law cannot even begin to encompass everything there is to protect within cultural rights. But I believe that it's a tool, and it's a tool that you can have in your pocket that you can use to help protect your cultural rights as a Native business owner and trying to protect your brand. So I think this quote by Walter Echo Hawk is really kind of puts things in perspective for me and how I want to present this information. Okay, so the first question is, what is intellectual property? And I like to break it down into 3 different categories. The first one being copyright, the next being trademark, and the third being patents. So at the end, I'm going to discuss copyright a little more in depth, but our main focus today is going to be on trademarks. And just to give you the sort of legal definition of a trademark, it's a word, a phrase, design, or a combination that identifies your goods and services, distinguishes them from the goods or services of others, and indicates the source of your goods or services. When you register a trademark, you're protecting it from being registered by others without your permission, and it helps you prevent others from using your trademark in similar or related goods and services. So it sounds like a lot, but this is kind of the culmination of what we're going to be talking about. Basically, you want to protect it so that others can't use it. And you want to make sure that no one can take it after you've registered it and do a similar product and use it for the same types of goods and services, thereby causing confusion in the marketplace. And just real quick, patents. Their patents are a little more scientific in nature, and actually lawyers have to take a special exam to be a patent attorney and to be able to do patents. Whereas copyright and trademark, those, when you go to register those can be done by anybody. Generally speaking, it can be helpful to have an attorney do a trademark or copyright for you, but it's not required. For a patent, not only do you need an attorney to get one, but it has to be a specialized attorney that has that access to the patent bar and has passed a special exam to do it. So just so you know, if you have like an invention, so a patent would be for technical inventions such as chemical compositions like pharmaceutical drugs, mechanical processes, like complex machinery, or machine designs that are new, unique, and usable. And what it does is it protects the inventions and processes from other parties copying, making, using, or selling the invention without the inventor's consent. One of the patents that I just like to talk about, because it's an interesting one, is actually, I don't know if you all recall, but Restasis, it was a drug. The company transferred the ownership rights for the drug to the St. Regis Mohawk tribe. And then the St. Regis Mohawk tribe licensed it back to the company for $15 million a year. But I think what a lot of people don't know is sort of the backstory behind why the St. Regis Mohawk tribe even did this in the first place, is because their waters are very polluted where they are. And so they were looking into a drug like this to help kind of take care of and cure members of the tribe. They were actually at one point not allowing or recommending that women who are breastfeeding not drink their water because it was so highly toxic. So anyway, this is a case that went up to the Supreme Court, and the Supreme Court ultimately said that the company couldn't have this relationship with St. Regis Mohawk. But it's an interesting look at patents and how they were being used between the company and the tribe. So I just mentioned that as an interesting fact. So when you think about patents, you'll remember kind of what they are. When we talk about trademarks, we're talking about either a design mark or a character mark. So those are the two type of the marks that you can actually register. And I just pulled a couple of the ones that I think are really interesting, but these are all native, either native owned individually or by a tribe. And I'm sure many of you are aware, there's a company I really love out of Canada called Cheekbone Beauty. It's owned by a First Nations woman. And so her design is that little, sorry, the picture is not the greatest, but that little C with the design on it. But she also includes the words cheekbone. So that whole thing you see there, she used to have these little letters that it would come in with seeds in them. So I know because I got one that had that. So that's what that white paper is. So if you look at that design C with the cheekbone, she has, and I looked it up, so she has a registered trademark for that. Not just the word cheekbone, not just the design, but the fancy C with the letters for it. And obviously she does makeup. I think it's just makeup and maybe some skincare type products. The one you see in the top right-hand corner, that's for B Yellowtail Goods and Services. So B Yellowtail is a designer, and she has both a design mark and a standard character mark. So in this photo, you'll just see her design mark. So I did look that up. She has registered that, and she did that in 2013. The B Yellowtail, the words with the design above it. And she does, I'm sure you all know, but clothing, dresses, skirts, tops, camisoles, that's what she was registered for with that design mark. And then I don't know how you say this, Bedre. It's a chocolate company that's actually owned by the Chickasaw Nation. I actually think this should have been in the standard character mark, because what they have registered is that it's sort of a design, because it's, if you look at the words and the way they're drawn, they've registered that design of the way the letters are drawn, the handwriting, and then it has the accent on the R. So that's what they've registered for their chocolates. They also have individual trademarks for the different types of chocolates that they have. But the one we're talking about in particular is this design that you see with the, I couldn't think of the word, cursive writing. So that's for the Chickasaw Nation. The tribe actually owns that out of Oklahoma. So those are just some examples of native businesses that have registered trademarks for the company that are design marks. In the bottom right-hand corner, that is actually my logo. It's just there for a design, but so that I'm embarrassed to say I have not registered as an IP practitioner. I have not registered my own trademark, because it's so hard to focus on your own businesses when you're focused on other people's. But I'm going to say it in a positive way, when I register my trademark, I would just register that design. And I'll tell you why later. But I just think that's interesting. So I actually went into the system for the United States Patent and Trademark offices, and I looked up these trademarks to make sure that they were registered. And it's interesting to see who has registered trademarks, what they're for, and how long they've been registered for in the system. So maybe another time we can like fool around on that website and look at it. It's actually a very complex way of searching and it makes no sense to me, but it's when you can find stuff, it's really interesting to see who has registered trademarks, especially for our Native business owners, and also to make sure that Native words and that are actually registered to Native businesses and not non-Native, which we'll talk about a little bit more. So I just wanted to pause here and just see if any of you all had logos for your brand or designs that represent your company or your brand. It looks like she said it's the corn, beans, and squash growing together, and she doesn't have a trademark yet.
Awesome.
Hey, Carrie, I have a quick question. Can you trademark fonts that you use in your logo?
So it can be like a stylized design. So that can be included in the design. So when you go to apply for the trademark, instead of a standard character mark, I would, there's a place on the application where you can choose whether it's a design mark or a standard character mark. And I would choose the design mark and then include the stylized font in it. Because I do think it makes a difference. And some people want to protect that font as a part of their brand and their mark. So I do think if that's really essential to your brand, then you should do it as a design mark. And oftentimes design marks are a little easier to get approved because with words, there's a lot of similarities, but with designs, especially intricate designs, and I'm looking at Chushka now, like it's a little, like you see her design here, it's a little harder to find like exactly identical designs. So sometimes if clients have a more common word, I will recommend that they go ahead and just try to register their design instead of both, because the design is usually pretty unique. I love the design. It's so cute. And I know what you're doing with your, even without reading the pet grooming, I already have an idea of what you're doing by just looking at the design mark. But that picture in the right-hand corner with the billboard, that would be, we're going to talk about this later, but that would be a good example of what I would call a specimen of a way that you're using your mark. So this would be a service that you're providing as opposed to a good that you're selling. And the billboard would show a really good example of how you're using it in commerce, which is what is required by trademark to get your application approved. And so I really like that she posted this because that's a really good example of how they're using their mark to in their goods, in their service, in providing their service. But I love the design. And we'll talk a little bit more about kind of the benefits to a copyright versus a trademark at the end. It's really beautiful the way you've integrated the words in there. And when I look at that, you know, that would be, so we're going to talk about this a little bit more, but this is a really good example. Some people would just register the tree. But I think the way you've incorporated the words in there, like it almost looks like it should go together, like it's an integral part of it. And so registering it as a design mark with the wording in there, I think is would be like a good start for something like that. But it's really beautiful. And another thing is I was talking a little bit, and I'll talk more about it, about the specimen. When you go to do your application for a trademark, you have to show it's really weird. It's a hard concept for me to grasp, but you have to show that you're using your actual mark in the service you're providing or the goods that you're selling. And so the way she's done this with her website is that would be what I would use as a specimen. It's such a strange word, but you have to, it sounds like you're going to a doctor's office, but you have to provide the USPTO with a specimen. So I would include your whole web page because it shows the service that you're providing with your trademark in there. And I really like your website too. Christy, do you know if they've registered this as a trademark?
So this is my company and I have not.
I like the way you have the ANC like incorporated in there. So again, this would be like a really good, like for your specimen, as we were talking about, just this whole website, because you clearly have your mark there. And, you know, you might just register that if you decide to the mark with the design with the colors.
And do you have to register it in every state in which you're operating, or how does that work?
No, that's what's beautiful about the trademark system because it's a national system. Once you register it, it's good for the entire United States. So if you wanted to have your mark registered in other countries where you might sell, that would be, or provide a service, that would be, you'd have to go by their trademark laws. But in the United States, if you get a registration with the USPTO, that's the only one you need. Now, some people will register it with their states for state protection, which is fine. But if you are providing services outside of your state, I always would recommend, there's a higher level of protection with the USPTO. That's a good question. So yours is unique too. And she has the design mark, which is the one we're talking about right now. But then she also has the word One World Rug Care. So, you know, you could register the design mark alone and the word alone, or you could do them together. So there's some interesting ways to protect that. We kind of talked about this because you all had these really interesting marks that incorporated word marks with design marks. But here's some examples where I found where just the words were registered. Okay, and I didn't do a very good job of Sister Sky. That's the one up here with the blue. So I did a terrible job of putting that in there, but it's for Sister Sky. And I couldn't find a design mark where they registered this flower type design. I could only find the words that were registered, and that maybe because the design mark is fairly a more common one, and maybe they couldn't, or maybe they just made a decision to only register the words. So I'm sure a lot of you have heard of them, but they do bath and body products. They're registered for namely lotions, non-medicated bath salts, bath and body oils, and there's a couple others. And again, they registered this one in 2002, and I couldn't find the design. So it looked like to me that just the words Sister Sky were registered. And then this is one of my favorites because it's a New Mexico company, but a Native woman owned Prados Beauty. And obviously it's cosmetics, is out of Las Cruces, and she does amazing social media videos and stuff to promote her brand. But I think this is just a picture of a makeup kit that she has. But when I looked up their trademark, they had just registered Prados Beauty. So I couldn't find any design marks, just the word. So again, it would just be the words without the font, without the color. Same with Sister Sky. It would just be the black and white. Again, they are out of New Mexico. And then here underneath you have GNU, which is registered out of Portland, Oregon, and they're known for a native company that does jeans, like really high quality jeans, but they do several categories, including clothing. And then here on the bottom, you can see B Yellowtail. So I apologize, I think I said it wrong. In the other one, it was the design. And then in this one, she just registered separately B Yellowtail with the spelling just like you see it. So those are just some examples of word marks that are registered all alone by themselves without any design element.
And Carrie, before we move on to the next slide, there is a question in the chat. So this probably was perfect timing, but just wanted to know, this would probably be the route you would take just to register your business name if you know you're going to change your logo at some point.
Yes, so that would be a really good reason to only do the name. If you thought like, I'm working on my logo, or there's something really like more intricate that I want to do that represents my business, that would be a reason to do just the word mark. So that is a good question. And like I said, with Sister Sky, because their design mark is fairly generic, and I use that term because that's the terminology that USPTO uses, because it's fairly generic, they may have only registered the words because they had to. But yeah, a practical reason would be like, and I've talked to clients who are like, hey, I have this logo I used since I started, but I really want to have something that more sort of represents me and my brand. And so, yeah, just to have it, I think it's good to have a registration in for at least the words, and then you could do the design mark later once you have your logo you know you're going to go with. Because once you've established that brand and you've done a lot of marketing under it, it's very expensive to change it all. And then the registration process can be expensive, in particular, if you use an attorney. So you would want to just be mindful that you don't want to spend all this money marketing and protecting your brand when you know you're going to change the logo. Okay, and she said her logo is stock design from Canva. Yes, and I would recommend like having something original or something done for you. And one thing, just this is a tip, if you do have another artist that's not yourself design your logo, you want to make sure that you have an agreement with them that you own the rights to it and you are able to use it. Like the copyright, you would want to make sure that you have an agreement, like I'm going to pay you a certain amount, and in return, I own the rights to it, because it could cause problems when you go to register your trademark. Like, let's say, I'm trying to think of like a really well-known brand logo, even the swoosh for Nike, right? If somebody else designed that and then Nike became really popular like it is, and then the original artist was like, hey, I want a share of those profits because that's my design, then you run into really big problems in copyright litigation and that kind of thing. Also with the trademarks, even if it's a handwritten agreement, that's fine too, but make sure you have, or an email back and forth where you say, please, I want this type of logo with this, these design elements. Make sure you just have something in writing that you own that, or that you're allowed to use it for, your business and for marketing purposes. That's really important. What should you register? So we kind of talked about this a little bit with the last question. That was very good. Your design mark or your logo, should you register just the word mark? You can do like the Yellowtail did and do the design element and then the word mark, but do it separate applications. or you could do them both together. We talked about that one with the resilience with the tree in the middle. Like that might be one that would be a good one to do together, because the design element is kind of incorporated in with the words. So I just wanted to know, and I see Nellis posted hers too, which is also beautiful. If anyone had any thoughts on which one, how you would go about it, and which one, like what would be the benefits or drawbacks to choosing one of these over the other.
Should we pull up the last two that have been shared in the chat, Carrie, and then we can dive into that question together?
Yeah,
that be-
sure.
Alice can share about her mark. Give me just a sec.
Sure. I just had a hey, Carrie, it's good to see you.
Hi.
And I'm sorry I couldn't see the kiddos running through. I actually just had a question. So the previous series session I had hosted, and one of the things that I had done is that I shared my logo, which is here. And someone had corrected me and they said, that's not actually a logo, that's a graphic. And it makes me think, like, what makes a logo then? And I don't really know. I mean, and when it comes to logos and graphics and trademark, what is this?
That is a great question. Because it is more of a graphic representation, but I'm not sure that that would matter so much to USPTO. I think if you had this picture, to me, looking at it from like the sort of black and white of USPTO, I would see the jewelry, the beautiful, and correct me if I'm wrong, but the squash blossom design as your logo. And then and I'm going to let you pronounce that because I don't want to mess up your language. But.
Thank you. It's Asa Consulting, which is Navajo for women.
So, that is definitely your word mark. And then I would say that even the graphic, that would be your logo. Even though it's a drawing, I hear like the distinction for other things, but I think for USPTO that would be your logo, because I've seen your marketing materials, which are beautiful, and you always use this design. So as long as you're always using it, and that's a really important part, usage is like essential to the American trademark system, that not only do you have to have a logo and a word mark, but you have to be using them in your business. So and that's something I would recommend for people who are considering trying to register their trademarks, is to make sure that like every time Nellis puts out marketing materials, that this is always there, or when Nellis does presentations, that she always has this there. When people go to her website, this is what they see, because that image and that logo is your brand. And you brought up something interesting, because I actually didn't know, and I should have asked you years ago what this meant. But so when USPTO does searches in other languages, sometimes they will ask you to translate. And so they would search not only what you have here, but women consulting. So when I do applications that are in other languages, especially native languages, I don't translate. And then I would wait for USPTO to ask me for a translation, because I don't know, it's just like a thing. I feel like if they don't know, then I'm just going to leave it there, because when they're doing the search, I actually would prefer they just search it this way and not compare it to women consulting, because that might be a more common one. But the way Nellis has it written in Navajo, it's not common. So the USPTO, then, if I were doing Nellis's application, I would do her whole word consulting, and would be a generic term because it's a common term. She can't claim anything to the word consulting, but I would try to register her with it in Navajo. And it could become a problem because they may make her translate it and call it women consulting. And then there might be others who are doing similar services, but I would argue to keep it like just in Navajo. But this is, I think, Nellis, if you were to register this, I would do like, I would either do it together or entirely like if you, so one of the things to think about when you're registering, and this comes up for a lot of us small business owners, is cost, right? If you do 2 applications instead of 1, you're paying double the cost. So for some people who, like me, budgeting is important. And then I would, if I had to pick, I could only do 1, I would register my design with the words in it. If I had the budget to, like with Nellis's, I would do the words as 1 mark and then like be yellowtail and then do the image, the design as another separate application. That way it kind of gives you double protection because you're protecting like Nellis's drawing and her logo, but she's also protecting the name of her company. So, but again, for a lot of us, that may not be an option because we are, you know, small business owners. And so when people come to me with that and they have, you know, budgeting constraints like I do, then I would recommend just to do it all as one. Because like I said, the design marks, especially Nellis's, is very unique. There's probably not a lot of other businesses who are providing the same type of consulting service she is that have that design mark. So I would think that she would have a greater chance of getting this approved all as one with the design rather than just the name, if that makes sense. But that was a really good question. So yours is also very unique. And so she has like the words incorporated into her design logo. And I would, so again, you could do with yours, because I have a feeling just based on seeing your name that that's a last name. Generally speaking, last names, you're not able to register them as a trademark. So like my business is Frias Indian Law and Policy. Well, Frias is our last name. So it would be difficult to register a last name. The exceptions to that are something like McDonald's or like Wendy's, which is a first name, because they have been used for so long and they're associated with that product. There's an exception for that under trademark law, but for our names, Kim, that may not be the case. So for me, I would register just my design. For you, I would recommend, if you ever were to register, to do just like you have it, the design with the words in it. And it's really beautiful.
And we have a question about how much does it cost to get a trademark?
That is also a great question. So it depends, of course, lawyerly answer, it depends, right? If you were to do it yourself, the only fees associated with it would be the application fee, which is right now $350 just to apply in one class. And when I say class, that means like, okay, for example, Nellis's, if she were to apply, she would apply under services under a particular class that incorporates the consulting that she does.
I had a question for us, because our logo itself is the Sharpay, like in the hexagon, and then I'm not sure if the correct terminology is like our word mark, or I'm calling it our slogan is to ensuring pets love grooming. And I know you explained that it would be beneficial to register. Well, I guess this is also just a question in itself. Like, would it be beneficial to register the logo in one class and then the word mark in another class? Or should it be done together? I guess I'm just looking for clarification on that.
Yeah, so that is a great question. And I remember yours. So that you brought up a really good topic that so slogans can be trademarked as well as so Lux Pup could be a registered trademark, and then your slogan could be a separate trademark. So like Nike has its trademark for Nike, the word, and then for the the design mark for Nike, but they also have a registered trademark for Just Do It. So you could, for Lux Pup, you could do like the design with the Sharpay in it, which is so adorable, and the hexagon. You could do one for that. You could do one for just Lux Pup. And then if your slogan is unique enough, you could also get your slogan registered. So essentially you could do 3 if you are using your slogan like in your business and that's your part of your brand, then you could try to get that registered too. But that brings up a great point that slogans that you may use in your business are also eligible for registration. Oh, I know what I was talking about too. I wanted to just mention this so you know. So the $350, let's say Lux Pup, let's say you were doing grooming, which is a service. So that's one class. And then you were also selling, I'm just making this up, you were selling like homemade like pet products like shampoos and conditioners or such for your dogs. That would be a separate class. So it would be the same Lux Pup, but you would be in 2 separate classes because you're selling goods and then you're providing a service. Or let's say you were selling your own homemade shampoos, and then you were also selling your own homemade dog treats. Those would probably be 2 separate classes plus your service. So that's 3 different classes. So when you're registering your trademark, I would recommend to register it for everything that you're using it for now. And there's another really unique thing about USPTO. If you intend to use your mark for a specific class, you can apply that you intend to use it. The only downside to that is that eventually you do have to actually prove to USPTO in a certain time frame that you are using your mark in business. But if you know you're going to do it, it's a good way to kind of reserve your registration for that particular goods or service too.
I have a question. If I want to register the logo, the company name, and our slogan, would that all be under the same class, or would it be like classified under different classes?
If you're just providing the service of grooming, it would probably just be one class, but it would be 3 different applications or 2, depending on how you register the design and the word mark, and then maybe the slogan separately, if that makes sense.
Okay, and then roughly, I guess since it would still be 3 different applications but fall under the same class, is that still like a rough estimate for like about $350?
Yeah,
and
$350 for each application.
Okay.
Yeah, and then if now the costs obviously go up if you have an attorney do it, and we'll talk about this a little later, but attorney will also do an extensive search before you even go to do your application. So some clients I've done searches for and I'm like, oh, I'm sorry, someone else is already using your same name and selling similar products to you. So maybe you might want to consider a different name, or we could go forward and try to distinguish your product from theirs. But the whole point of the system is to cut down on market confusion, so that, like, let's say I'm kind of making that, well, let's say there was like another grooming service, but they weren't nearly as good as you guys, and they didn't provide the same quality of service or the same products that they use on their pups when they're grooming them. You don't want that brand to be confused with your brand because maybe they're not as good. And so it could lower the customers you could get, that kind of thing. And that's the whole point and what we're trying to prevent. Right. Okay. So Kim asked a question about renewal. So if you got registered in 5 years, you would have to show that you're still using it to keep your trademark. And then you would need to do that again at 10 years. And then it's as long as you're using it and you on those 10-year bases, you're continuing to renew it, then it will stay valid. So that is one of the benefits of a trademark, a registered trademark, as opposed to a copyright, which is only good. I think it's 70 years plus the life of the author or the artist or whoever created it. And patent is, I'd have to double check. I'm not a patent expert, but I think it's like 20, 25 years. That's like, when like the drug companies, when they run out of their patent time, then people can make like generic brands. That's why, because the patent has expired. The 5-year renewal fees, that is a great question. I want to guess it's less than $350, but I can check on that for you. Lux Pup asks, what are the 5-year renewal fees? And then Kim asks, are there edits, changes treated as a new application, or is there a modification process? So that is a lawyerly answer. It depends on what you're modifying. If you do an application, you have 5 different classes. Like you say, I'm going to register my mark for clothing, for shoes, for hats. And then you decide later on that you want to take 2 of those out and just do hats because that's all you're actually producing right now, then that wouldn't be, I don't think there's any fee for that to change it. There are some things that you cannot change. So like once you put in what the name of your mark is, you can't change that. Sometimes you can get extensions to certain deadlines, and those are usually about like $100, but things start to add up. So it's really good to have a really clear process before you jump into this, because it can get expensive. If you hire an attorney to do it, fees vary. But one thing I do want to caution you against is I would say at least maybe talk to an attorney, because there's these services where, they just charge you like it seems like a not very expensive amount, and then they just kind of automatically do it within this big system. And those usually, some of us attorneys who practice in IP, we end up having to fix those applications later down the line. So sometimes what may seem like a cheaper option to go with one of these big companies, I don't know why their names are escaping me right now, but I'll think of it in a minute. Sometimes when you go with those big companies that all they do is push out applications, they're not as precise as like an individual attorney would be in helping you through your application process and doing the search. And so sometimes it ends up costing you more if someone has to go back and fix it versus sort of just paying the upfront fees. So it's a lot to think about, but I think there are times when it can be done without an attorney, but it's, if you can afford to at least like get some consultation on it, it's better to have, some guidance on it, especially if maybe you're doing a lot of classes, or your mark is just a little more, if there are some issues, and it just really depends. It's so hard to say, but at the very least, you would pay $350 for the application fee. But that was an awesome discussion. And then, so this is like kind of some painful stuff to talk about, but I'm sure I don't need to convince any of you of this, but basically I want to just talk a little bit about why you should care about a trademark. And many of you might know this example up here. This is Urban Outfitters. So Urban Outfitters made these underwear called the Navajo Hipster Panty. And then you'll also see, I found some other examples. This t-shirt is called the Techno Navajo Quilt Oversized Crop Tee. And then this one I find equally as disturbing, the Navajo Print Fabric Flask. So they were calling their products Navajo, and they were using the word Navajo in them. Super offensive. And so the Navajo Nation actually sued Urban Outfitters in this case for use of the word Navajo. So they did a trademark infringement, which means that Urban Outfitters was infringing on their trademark rights of the Navajo Nation. And they also did dilution and violation of the Indian Arts and Crafts Act. So they ended up settling this case. So when they settled, that you don't really know like the amount or anything, but they basically signed a supply and license agreement, which is a really interesting way to handle this. So that what I would assume is that Urban Outfitters, if they want to use the name Navajo, they have to pay the Navajo Nation for the license, and the Navajo gets to decide where its name is used and for what. Probably not hipster panties or this print flask, but they could, Navajo Nation gets to say what it can be used for, and they have to get paid for it because you're using our name. And they were going to do a plan to collaborate on authentic American Indian jewelry in the future so that Urban Outfitters could actually sell like, I assume Navajo made jewelry. So I think that's a really good example of what Walter Echohawk was talking about in the beginning about cultural appropriation, and how the Navajo Nation having a registered mark could help prevent Urban Outfitters from using it in a really unflattering is not the right word, but in a really negative manner, like you see here. And not only that, but making money off of the name Navajo to sell products. And I have a couple other examples. So this is the Lumbee tribe, in North Carolina. The top picture that you see is from their website. That is their seal, their tribal seal. And their, not their mission statement, but something along those lines beneath that: heritage, pride, and strength. And what you see below is a Budweiser. This was in a convenience store, I think in North Carolina, where Budweiser had these advertisements made, and you see it's above the fridges where they sell the Budweiser beer. And they have in the right-hand corner with the circle, they have the seal of the Lumbee tribe, and they're also using the words heritage, pride, and strength. And the Bud Light is right above it. So the Lumbee tribe of North Carolina filed a federal lawsuit against Budweiser for trademark infringement and unfair and deceptive trade practices. And because the Lumbee tribe's name and appear in close connection with Budweiser and Bud Light trademarks in a manner that suggests that the Lumbee tribe is the one that's promoting the sale of Budweiser and Bud Light. And so that's what that lawsuit is about. And I don't know if they have come to resolution on that one yet, but so you can see it's like I was talking about before, it's confusing because we're assuming that Lumbee is promoting the sale of beer. And then here are a couple other examples quickly. You see the Zia flag up there in the left-hand corner. That is actually a very traditional symbol that the Zia Pueblo has used in ceremony from before there were any non-natives in New Mexico. And because the Zia symbol is now used as the flag of New Mexico, the Pueblo of Zia cannot register this as a trademark. So other companies, the state of New Mexico, are making loads of money off of this symbol that's actually a cultural and a religious symbol that they've used, you know, from time immemorial. So that is a disturbing example. And then you have here the Aloha Poke Company, which is a Hawaiian word, and it's actually a Chicago-based restaurant company. And this company sent cease and desist letters to Native Hawaiian businesses for using their name, which is a Hawaiian name, and the Chicago-based restaurant company was not Native owned. And then you have here Crazy Horse malt liquor, again, using the name Crazy Horse in the sale of liquor and not owned by a native, not native owned. It's Hornell Brewing Company that does this, and it's Crazy Horse malt liquor. Again, I'm sure you've all seen Jeep Cherokee. The former Cherokee chief called on Jeep to end the use of the Cherokee name on its cars. And Jeep responded, "Our vehicle names have been carefully chosen and nurtured over the years to honor and celebrate Native American people for their nobility, prowess, and pride." That was in 2021 that Jeep said that. And of course, the Atlanta Braves, they have a registered trademark for the Braves. And finally, Natural American Spirit cigarettes. It's a New Mexico company. They are out of North Carolina, but it is not Native owned, and they use the Native American symbol down in the corner with the red, and they have a registered trademark for that as well. So these are examples of how trademarks can be used by non-natives to appropriate culture and marks of that should be tribally owned or individually owned by Native Americans, if at all. So it just kind of goes back to our example in the beginning, like if you are able to use your use a USPTO to utilize it to protect your design and logo, and you know, your logo may or may not have cultural ties, but regardless, you know, it is important to protect that brand. And you can see how other non-native companies are making money off of native designs. So I just wanted to show that, and I'm trying to go through quickly so that we can have some time for questions. Just real quick, oftentimes people have questions, but that the TM mark in the right-hand corner, you can use that symbol if you've applied for a trademark, but you haven't yet received your registration. The R circle is when you have a good that has been registered with USPTO, then you should use that R symbol, and that indicates that your mark is registered. The SM is a service mark, so like Nellis's consulting company or Kim's consulting company, if you got your trademark or your mark registered, you would use the SM with the circle. And that would mean that your consulting business or maybe Lux Pup too, you're providing a service. So if you got your trademark registered, you would use the SM symbol. And just real quick, we kind of talked about this already, but in order to apply, I strongly recommend you do a search. And there's companies that can do this, or even just yourself looking through the USPTO has a search engine, and just see if anyone has registered marks. Even use Google and see what other companies are out there that might have the same name, and then search and see if they have a registered trademark. That's followed by the application process. And then the applications go to attorneys that are hired by USPTO to review the application. And what they're reviewing for is a strong mark. So anything that is distinctive, descriptive, fanciful, or arbitrary, means like kind of random words that wouldn't be used by a lot of other people. Very like fanciful is like a very unique design. So the weaker, as you go down, the more generic your terminology or your designs are, the less likely you are to have them registered, if that makes sense. They're stronger if they're like kind of made up words or very unique designs that other people would not be using. And then after that, your application, if it's goes through the attorney process and they approve it, it's published. Oftentimes the attorneys will issue what they call an office action saying, oh, I'm sorry, somebody else is already using this, or it's too generic, and you can choose to respond to that or not. And then if your application gets approved, it gets published and then registered. And then I think Kim was talking about this. You have to maintain and protect your mark over time and show USPTO that you're still using it. And I'll go quickly. Just really quick, I just want to end on this because I think copyright, this is a symbol. You can use this symbol as soon as you create something. So Christy Williams, like her design, she could put a little C with the circle around it now. And what that means is, so a copyright is different from a trademark. As soon as you create the work, you own the copyright to it. What the Copyright Office does is they can register your copyright. So similar, like you have a mark, but when you do trademark, you register it. Same with copyright. Everybody owns their copyright, but registering it helps you to enforce your rights. So copyrights protects original works of authorship as soon as the author fixes the work in a tangible form of expression. So it can be paintings, photographs, illustrations, musical compositions, sound recordings, computer programs, books, poems, blogs, movies, architectural works, and plays. So one thing I like about copyright is it's a cheaper process. It's only about $35, I think it's $35 to register, to do the application for a copyright. So it's cheaper. Also, if you find that someone is using your registered copyright, it's a little easier to enforce than a trademark. Trademark, you basically have to go through administrative court process, and it's expensive because you have to use an attorney. Copyright, they have instead of, you can go to federal court, but they also have an administrative process that is a lot more accessible now that you can use to enforce your copyright. And in addition to that, copyright, there's money. It's easier to attain money damages when you can prove that someone is using your copyright to make money. So there are some benefits to it, as opposed if you maybe can't afford to do a trademark at this point. Think about maybe just copywriting your design elements for now, and then going for a trademark later on. So I just want to mention that as another way to help protect your brand. And I'm sorry, I tried to rush through the last bit of it so we'd have a few more minutes for questions.
Yeah, so if anybody in the audience has any questions, I invite you to either drop it in the chat or come off of mute and ask your question. I know for me, just real quick, oh, go ahead. Go ahead, Kim.
So just for us to figure out where we're at in this journey and figuring out like maybe it's better for us to do copyright now until we're ready. Is there like a readiness checklist or some things that we should ask ourselves so that we can figure out which path we should take? And then if it's cost prohibitive for us, like what are some guidance in terms of what to look for if we decide to try to do it on our own or work with a professional like you?
So that is a great question. And I'm actually going to look now on the trademark website, because they have these great videos. So that's one thing. If you wanted to do the trademark yourself, like you absolutely couldn't afford an attorney, which makes sense. If you go on USPTO's website, they have all these videos, and they even have like free kind of classes that teach you about the application process. It's time consuming to sit there and watch them all, but if that's what you have to do, I would highly recommend them because they're very good. And same with the Copyright Office, they also have videos. So the copyright application itself is a little easier to do yourself than the trademark one. But if you have to do it yourself, go to those websites and spend the time watching the videos, because I haven't had time to watch them all myself, but I've heard they're very, very good. And I have used the information on their websites for some of my own applications. So it can be a little overwhelming because there is a lot of information, but if you look in the video testimonials and things like that, you can find on USPTO. I know there was actually recently, they ran a trademark basics class, and every week, and I'm sure those videos are uploaded to their site, where every week they went over a different step of the application process. So you can do that. The readiness check, that is a great question. I'm going to look and see if there's anything. My suggestion would be, if you're not really sure, to register your copyright first and go through that process and get, and you don't have to restrict it to just your logo. You can, I have another client who I did their trademark for them, but they also had a bunch of Native artists' work on the website that they wanted protected, really beautiful artwork that they had contracted for. So they actually did have a contract. One, they didn't, and so we haven't registered that copyright, but I did their copyright applications for all the other images on their site. So again, that's a good place to start. It's much more affordable to do those applications. And if you have any question about whether you're ready to register your trademark, I would say go ahead and start with the copyright first. But as to whether there's like a readiness thing, I don't think so, but I will look, because that's a really great question. How do we know if we're ready to file yet? So I'll look and see if there's anything out there, but that might be something, we could create. And I think Jennifer put the websites in the chat.
Yeah. Yeah, I just wanted to share those resources. and point you all to the Learning and Resources tabs on the USPTO. I can share my screen just real quickly. I know we are almost at time, but just wanted to share. This is the correct
Yes.
website. Is that right, Carrie?
Yes, no, you got it.
Okay, and then here's the Learning and Resources tab. So hopefully that is helpful to you all. And then this is the copyright website. And not too sure where the resources are here, but feel free to navigate.
Their website is awful. They could use your all help on doing it, but I would say like the Learn More tab, I've used that before, that blue one in the middle of the screen. And then if you go down to the individual sections that you have questions on, if you click on those, but their website is like, especially their application is kind of like an ancient, you guys would be surprised that they use that system, but based on how beautiful all your websites look, I'm sure you could navigate it just fine.
Awesome. Well, we are at time and just want to respect everybody's evening and your plans. Just gonna go ahead and share our closing. Thank you all so much for joining us today. Here is a QR code where you can access registration for our future virtual programming events, resources and information for our organization on this link tree. Just thank you so much, Carrie, for sharing your knowledge and expertise with us. It was so helpful. And feel free, everyone, to share your contact information in the chat so we can reach out to you all for your services and for your work.
I was about to say that too. It's really good to have had the workshop and then have this right afterwards. It all's connected. So it's great. So thank you so much.
Yeah, so good to see you, and I'm looking forward to continue to share resources and collaborate for sure.
Yeah, definitely. Thank you. Thank you. And have a good rest of your day.
Thank you. But just wishing you all a great rest of your day, and thank you so much for your love, care, and energy for our group today. And thank you so much, Carrie. Just really, really appreciate the information. Like, I learned so much.
I hope it wasn't overwhelming, but thank you for having me. I really appreciate you and your calm nature. Like, you calmed me right now. And I just thank you for your help. I really appreciate you all and the work you do.
Absolutely. And the feeling's mutual. Thank you so much.
Thank
Have a
you.
good rest of your day.
Bye.
Bye.